Welcome back to the main auditorium. I hope your one-stop shot of coffee was able to put you in an even better mood and focus for what is about to come. And indeed, going back to the key focus of the conference, and namely effective enforcement in the digital world, what is yet to come? Now what? To answer this fundamental question, there is no better person than the EDPS himself to do so. Ladies and gentlemen, I have the great honor of introducing to you the European Data Protection Supervisor, Mr. Wojciech Wiewiórowski.
Thank you very much. I hope that I will survive all the emotions that are right now in me. Good morning. Thank you. Thank you for being here this morning. Thank you for being here with us for the second and the final day of the conference. I'm so grateful to have the opportunity to bring so many people together after this 2 years' time. And I'm also proud of EDPS team that worked around the clock for last months to prepare this conference as it is now. I understand why so many of you were asking me why EDPS is organizing the conference and why with this title. Today I would like to tell you why. Because it's the highest time to deliver the promise of the landmark legislation that the GDPR is. Because as EDPS, I'm personally responsible for this. Well, I'm the advisor of the EU institutions. Because there's no such thing as standing still and not reacting. Either you move forward or the world moves without you. And clearly, this conference shows me that there is a path we can follow. We can finally deliver what we stated 10 years ago in the January of 2012, when the GDPR proposal has been announced. Back then, Joe McNamee from EDRI, whom I love very much, and who taught me a lot about data protection, said that there was a desperate need of a stronger enforcement in the member states. It was echoed by the draft GDPR preamble, calling for a strong and more coherent data protection framework in the Union, backed by the strong enforcement. In the past hours, today, yesterday, at this conference, we heard many similar statements. And this is why, at EDPS, we wanted to come back to the drawing board to sit down together with all of you and reach conclusions that can inform the public debates. The public deserves it. Things that can be delivered now should be delivered now, not in some unspecified future. And let me first try to summarize the discussion that we had so far. I'm thankful to everyone who does not shy away from facing difficult questions, who tries in the spirit of leadership and responsibility to bring the progress. Listening to the conference discussion, I see a lot of dedication and passion. I see the sense of pride behind the GDPR and the sense of expectations that Europe will continue to lead protecting digital rights. I also see hopes that certain promises of GDPR will be better delivered. I believe we still do not see sufficient enforcement, in particular against the big tech. There are structural obstacles that were mentioned here. That's unequal burden sharing. That's procedural law differences which are hampering the cooperation. The involvement of the EDPB comes sometimes too late and probably too little. Why too often the GDPR puts its constraints on small entities but spares the big ones? In a way, instead of achieving the level playing field, we observe how the big companies, thanks to the resources they have, can benefit from the lack of strong enforcement and further expand the advantage over the small competitors. We also can see that individuals who wait for years to obtain the justice, even if in what can be seen as small and simple cases. And with the plethora of the new legislation, so-called digital rule book, the data protection framework is at risk of becoming an orphan of the EU law, a hope that once was, but no longer is. We can also observe that when the data protection is taken seriously, when it means the public authorities, for example, cannot for once do something they were used to do, attempts appear to either threaten the independence of the DPAs, or we can even see the attempts of legislative intervention, which is to counter-effect the decisions of the regulator. We have heard yesterday the call for study on differences in the enforcement in the public areas, in the public sector and in the private sector. And I can join this call, pointing that even the EU legislator, proud of rigorous standards for companies and individuals, starts to modify such standard with retroactive effect when it was enforced for the first time against the EU agency and the member states. And of course, I mean the review of the Europol regulation now. So what's the way forward? The coat of arms of my hometown Gdansk says, nec temere nec timide, without fear, but not too brave. The discussions held so far on this conference showed that what we all share here is the one common objective of protecting the people. But where do we go from there? How do we achieve an overreaching standard of compliance across all the member states? At EDPS, we have a double commitment. We apply and enforce the law in the interest of the people it aims to protect, but also it identify the areas for improvement, and we propose the way to reach them in the future. That's our advisory role for the EU institutions. It's with this mindset that EDPS approaches its role in respect of functioning of GDPR, such as providing EDPB with secretariat and finding the sufficient resources, by proposing initiatives such as support pool of experts, by actively participating and contributing to numerous actions, such as coordinated enforcement framework. I'm glad that the Vienna statement promises closer cooperation for strategic files. We are confident that EDPB will play an increasingly decisive role through opinions and dispute resolution cases. We are proud to see we are all, as data protection authorities, doing better today than we were doing yesterday. And I think Aleit has presented it very well with the numbers today in the morning. But there is, however, also tomorrow. And the title of this conference is has the word future in it. We all gathered here to have a say over how the future of the data protection will look like. We can define it, we can shape it. So how do we want tomorrow to be? Let me start by clearly stating that EDPS is not proposing the reopening of the discussion on the substance of GDPR. And of course, by no means we are endorsing any attempt to weaken the principles of the GDPR. I notice at the same time that new governance model appearing, for example, in the Commission proposals for digital rulebook, the DMA, AMLA, banking solutions, they look like a lesson learned from the GDPR. They show that reflection on the governance model can be independent from the debate about the principles, and they aim to create the new standards. Today in the morning, Marie-Laure explained us how a fully centralized model of enforcement in data protection is constitutionally impossible, but it's also inappropriate. but expressed the path to more coordinated approach, I would maybe like to go one step further in this discussion on cooperation inside the EDPB among the data protection authorities, but as Marie-Laure said, in a kind of centralized system, which one-stop shop actually is. I share the views that leaving the procedural laws fully to the domain of the member states is causing critical problems for the cooperation between data protection authorities. Critical problems, which they leave individuals without the protection that the GDPR promises them, and I'm glad that we are now ready to talk about this legislation. In my view, the harmonization of the administrative procedure, however, can bring the added value only if it covers the broad range of aspects, which I actually find very unlikely. For example, harmonizing deadlines is hardly advantageous without the common understanding of what is the final decision, what constitutes the final complaint decision. Similarly, agreeing on what is the nature of the decision would most likely have to result in a deep harmonization of the national law, such as the right to be heard. And it brings us to the question, with principles of subsidiarity. The limited harmonization will not radically improve the functioning of the one-stop shop, as it will not overcome the real structural differences. I believe that harmonization may help, but by no means it's a silver bullet. Also, with the burden sharing, it's hard to find the silver bullet. Yesterday, we discussed whether the model that assigns responsibility for the success of EU law to the very few national authorities is fair. Does it ensure effectiveness of the EU law? Is one authority, two authorities, is an optimal design in the way to have the decision taken? I also find the cost of one-stop shop increasing. It is becoming an expensive shop. And while EU citizens are expected to pay their cost, they often do not get enough in return. Is it really the luxury that we can afford? Discussions on burden sharing within EU are as old as the European project itself. The development and the success of the EU integration can be, however, summarized with two words: stronger and together. This success is based on continuous reflection on how to share the tasks between the member states and how to be the most effective when you are assigning the compliance of the EU institutions, agencies, bodies, when you are assigning the competence to the EU institutions, agencies, and bodies. That brings us to the role of EDPB. I share the views expressed by some here at the conference that the current model, where the EDPB interventions are coming too late and their impact is therefore limited. I believe this needs to be changed. The commitment of the EDPB Vienna statement of last April is the first good step, but we need many steps more. I strongly believe that following the well-known examples which I said about from the field of the EU law and the new trends that are appearing in DMA, in AMLA, in banking law, at a certain moment the pan-European data protection enforcement model is going to be the necessary step to ensure real and consistent high-level protection of fundamental rights to the data protection. I don't know, maybe we are talking about some litigation panel at the EDPB, just to divide the political discussions and the practical discussions of the enforcers and the decisions which are taken on all European level in these biggest cross-border cases. Such model would not only mitigate the problem of uneven allocation of responsibilities, but it would also ensure the real consistency across EU, including through the strong mechanism of collegiality. I do not want the case against my local coffee shop in Gdansk, in my hometown, to be analyzed in Brussels or in Tallinn or in Lisbon if we create some one only centralized body. That's, of course, not the way. 99% of cases, 95% probably cases are local. 99 are national. But there are the cross-border cases. And I would like the serious cross-border cases to be handled on the central level on the basis of the simple procedure and transparent procedure. I also see the advantage of such model in respect of the issue of specific differences between procedural laws. With full respect to the principle of subsidiarity, key investigations based on the certain threshold, well, modalities of this should be discussed further, would be conducted at the central level. And this it should be the subject to the scrutiny of the Court of Justice, of course. Therefore, overcoming potential issues stemming from the incompatible national legislations or patchwork of harmonization attempts, we have the path to go. Dear friends, I will stop here. I shared with you my first thoughts after what I heard, and my way of listening to the conference as well, and the issues we are discussing at this conference are in the middle of our thinking about the future. I'm impressed by the discussions held so far, by your contributions, views, comments. I'm proud of the community gathered here, committed, passionate, able to continuously find ways to improve. I see the consensus about the need to step up the enforcement efforts as the clear indication of where should we focus in the nearest future. I deeply believe that the closer integration is needed if we are serious about protecting EU citizens' personal data across the whole EU. The weaker when divided, the stronger when together. Thank you.
Thank you, dear Wojciech, for such inspiring words. I'm sure that these will not only stay with us for the next days and months, but will also inspire future and concrete actions in the coming years. Please join me once again in applauding and thanking Wojciech Wiewiórowski.